Welcome, Emily, for joining us so early in the morning for
Yes.
our webcast.
This is for you, Mike. For you, I will get it. I got up this early. It was difficult to drag myself out of bed. The alarm went off, and I pushed snooze a bunch of times. But I said, no, he needs me. I promised. And so I got up, and here I am.
You're not just doing this because my former boss is now an employee of yours, I think. Is that
no, you know what? I'm pretty sure that I don't even know if Tim's up right now. But no. Actually, it's kind of fun to. He was my former boss too, because remember I used to work at the Bar Association for a little bit. So it's kind of fun to be able to tell my boss what to do. My former boss.
Is that why he was hired? Just for that opportunity?
You know, that may be part of it, but he actually is doing a fantastic job. He's you know, it was weird because I worked at the Bar Association a long time ago, and while I was there, I was doing work with the volunteer attorney program, MVAP there, and in doing so, I made connections with a lot of legal aid people, which allowed me to leapfrog from that into working for legal aid. And then opening my own firm. But Tim Groshans, the former executive director of MSBA, he retired, I don't remember, how many years ago was that?
Oh gosh.
A year and a half, 2 years ago?
Yeah.
3. But it had to be about at least 3.
Yeah, at least 3 years ago now.
Yeah, I think at least 3 or 4 years ago, right after he had just retired, I was at the Family Law Institute, and I happened to see him there, and I was like, what are you doing here? And he's like, oh, well, I'm retired now, and I'm trying to figure out what I want to do. I think what I really want to do is I want to go work in the area of family law, and I want to do sliding scale fees. And I was like, what? I'm like, wait.
Did he know?
I don't think he even knew that that's what I do. And I was like, what are you talking about? And he's like, yeah, I'm here to do the new lawyers track on divorces to figure out, how actually procedurally all this stuff works, so I can kind of figure out how family law works. And he was planning to go, do clinics, and he has a place in Kandiyohi County, and he was going to do clinics there and all this kind of stuff. And I said, well, let's have lunch. So we had lunch at the family law clinic, and it just took off from there. And now he's working for me part-time. He does my intakes, and he also does helps start cases, and some of the simpler cases that he's learning, that he wants to learn on, he can pick and choose, I want to do this case and handle it. And so he's learning how to do the practice, and comes to me all the time if he has questions about some of his Kandiyohi pro se things going on, and to get some feedback on that. But I mean, he's doing a great job. He's also helping. We do a bunch of pro bono clinics, and I put him on the panel for that, to kind of do that for various places. And he seems to really enjoy it, and he does a really good job. Really, sometimes it's difficult working with people who are lower and middle income. You can get some interesting calls coming in, and he handles them with patience, and he's a champ. I mean, it's fun because he also, he has a place in Puerto Rico. He hasn't been there for a while because, he can't travel there. But before the pandemic, he would go to his place in Puerto Rico, and he would do all the intake calls from there. So he was never skipped a beat, and he was
ahead
always
of his time. Yeah. It's interesting. I knew he wanted to get into family law after retirement. I think he maybe even talked about that publicly, but I didn't know that sort of a sliding scale, Low-bono, unbundled, or whatever it might be, was part of his next plan. And that's I want to chat about that, because that, as I understand it, is really at the center of your business plan, as part of your practice. I'll just remind folks too, if feel free to chat in your questions, comments. There's a Q&A feature. We're watching both here and on YouTube. If you've got a question, feel free to throw that into the chat. But yeah, so tell me a little bit about doing family law as a sliding scale fee. I've talked to other practitioners and in family law where we've tried to promote, for example, like document assembly. Maybe you could do a flat fee, because these are regular processes that you're usually going through. And most of the family law attorneys I've sort of pitched that idea to have said, no, that's really not possible. with a family law practice because there are too many contingencies, there's too many unknowns. So I'm eager to know more about how you make a sliding scale fee work as a successful business model. I mean, I've got your website up here. You've got lots of folks, including Tim, working for you.
Yeah, we just actually we just redid the website at the beginning of the pandemic, which was kind of fun. That had been something that I had wanted to do, and actually we're really busy, but as you can imagine in this climate, but I think that the thought process behind it. So I had worked at Legal Aid, and while I was at Legal Aid, so many people were calling, and Legal Aid couldn't help the vast majority of them. I mean, at least 60 to 70% of the people were turned away with no help at all. And many of the ones that did get help just got legal advice letters. Full representation for somebody was pretty rare. And a lot of people were turned away because financially they didn't qualify for legal aid. And so at that time, a good friend of mine, Tracy Reed, and I worked at the legal aid office together, and we decided, hey, you know what, why don't we try and create something that's the next tier, helping those people who don't qualify for legal aid, but can't afford the prices. And I've had to hire attorneys for family law reasons, and wow, it's expensive. You hire somebody for $300 an hour, and by the time you're done just getting the initial drafting done, you could be $3,000 or $4,000 into it. And back when I was on a legal aid salary, that was nearly impossible to afford. And I could only imagine that other people in that middle income couldn't afford it either. And so we decided to branch out, launch our own sliding fee firm. And our goal was not to get rich, not to do anything, but just to do it and to meet that need and to serve that community. And so we did. We basically, there's other firms that I've seen that say, okay, I have this rate, but if somebody comes along and they're super poor, maybe I'll cut my rate for them, and that's my sliding scale fees. We don't do that. Everybody who calls is assessed, and they have an individualized rate based on income and household makeup and so on, and it's worked.
So I'm wondering if you could dig into this a little bit more, if it's not a trade secret of yours. Because as you've said, I hear a lot of people saying that they have sliding scale fees, but it's case specific, or they kind of go based off of a lot of different factors. Some people I think I've talked to even say, well, I ask them for a copy of their tax return, and based off that, I decide what I'm doing. How do you go about making that determination on the sliding scale, and where that person lands on the sliding scale?
I mean, it's pretty simple. It's same as what your other people have said, although we don't go down to show me your tax returns. We basically get their income information, how many people are being supported on that income in their household. And we have a chart, and and we price it based on that. I think the biggest problem that I see for people who are trying to do sliding fee work or working with lower middle income people is the people who really want to do that the most are kind of like super sympathetic and idealists, and I want to help. And they're terrible business people. They don't understand that behind the scenes, to make this work, you have to run it like a freaking business. Because if you don't, you will not survive this. I've had to change. I've had to change my mentality. Instead of just coming in this and instead of being like, I just want to do legal work and help, I have to manage. I do more management and administrative and visionary type work than I do legal work now, because to scale the firm, because we now have 2, 3, 4. I mean, we just added a contract attorney. We've got like 5 different attorneys and a bunch of support staff doing this work in addition to me. um, to be able to scale to that, and I have a full-time director of operations who helps me to like launch projects and make and keep moving things along. That requires really doing business work, being a business, and not necessarily just being a law firm. And I guess one of the advantages I have is I'm kind of good at it, and I enjoy it. And so that has helped tremendously. And I think without that, we wouldn't be where we are today. And I've done a lot of things to get to this point. I've done coaching. I'm involved in a lot of mastermind type groups and things like that. And without that, I don't think I would be where I am today, as far as how the firm is going and where in the direction that I'm moving.
You identified need, which is, and as you say, lots of folks understand the need, but how did you get from there to projecting, you said you're a business person. How does the business plan come into being when you're doing a sliding scale model? Because you don't necessarily know what's coming in the door. What are your bare minimums? How do you do projections? How do you do business planning before you even get started on a sliding scale model? Are there principles for that, or did you learn those as you came along?
I think I just learned as I went along. I think we were just lucky. We just set our scale and said, this is what we're going to try doing. And, when Tracy and I first started, it was originally Cooper and Reed, and now it's Cooper Law. When we first started, we had nothing. We walked out the door of legal aid without a single client to our name, and immediately started meeting people in coffee shops and trying to figure out how to network and do all that kind of stuff. So we had to do the legwork that everybody has to do for any kind of firm. You have to reach out, you have to make the connections, you have to market yourself, you have to network yourself, you have to find the places where you show up so that other people can find you, or the people that you want as your clients can find you. We had no rhyme nor reason to it, because we hadn't gone through any coaching sessions or masterminds or business planning workshops or anything. We just did it because this is what we thought in our hearts was the thing we wanted to do. Since that time, though, I have learned quite a bit and done quite a bit of self-education and participating in different things. And now I work more on a planning basis, and how am I going to project how things are going to work, and putting that together. I actually really, if you think about it, I think statistics say that like 70 to 80% of the people who show up in family law don't have an attorney. Now, not all of them are doing it because they can't afford an attorney. Some of them are like, I can do this better than an attorney. So they're going to be pro se no matter what you do.
Right.
But there's a significant amount of people who are doing it because they can't afford attorneys, or they think they can't afford an attorney because they don't know what their options are. And so they just do it, and they're trying to get through it and muddle through it themselves. And on many occasions, messing it up, especially in family law. So if you think about that, and I actually just did these stats last night because I'm writing an article for Minnesota MNBAR.
Right.
And over the past, since 2014, from 2014 to 2018, according to the annual reports for the Minnesota judicial system, there was somewhere between, it was like 42 to 43,000 family law cases filed on average in Minnesota. Now, if you think about it and you break down those numbers and you say 70% of those, somebody doesn't have an attorney, or 70% of the people that participate in those don't have an attorney, there's about 2 people per case. That's like 60,000 people who have no attorney in Minnesota every year in family law alone. And if you look at all the other different practice areas, there's like 1.2 million cases that are filed. And that doesn't include things that don't even require filing, like estate planning, right? That doesn't include bankruptcy that's in federal court. So there are thousands of people in Minnesota who need attorneys that aren't getting attorneys because they can't afford it. And so there's a huge market. And, and a lot of people, I think there's a lot of competition when you're talking about the upper 5 to 10% of people. Of the 30% of people who do have attorneys, you're going to say maybe 10% of them have a legal aid attorney, and 20% of them have a private attorney, maybe that are, charging them those higher rates. And it's true that if you charge those higher rates, $300, $400, $500 an hour, you need fewer clients to who, if they're paying that, you need fewer clients and fewer hours to make the same amount of money that I would make with somebody who's paying me one of my lowest rates. Maybe they're paying, you know, 95 an hour or something like that. I'm going to have to work obviously 4 hours to meet the same 1 hour that a $400 an hour attorney can pay. But if you do it right, you know, you can have an unending stream of clients. And if you do it right, you can have you can make it work financially. And so what I'd really like to do, because, you know, there's always that, you know, for that upper 20%, there's huge competition. Everybody's going after them and wanting them. Right. I actually would love to be able to create a way to teach people how to do the sliding scale fee version of it, because I think it's a need. And, you know, and I guess that transitions into everybody's talking about these limited legal technician things that they're trying to get in, where they're trying to have non-attorneys represent people. I think there's a significant number of attorneys who aren't getting enough business and aren't making ends meet well with their solo practice or their small practice, that could enhance their practice by creating a real sliding scale fee model for their practice. But it requires a whole different mindset that I think a lot of attorneys don't have or haven't developed for themselves.
Yeah. Well, it's interesting for you to even define that as a market, those 60,000 folks who don't have an attorney. Typically, I think especially here at the Bar Association, we talk about that as the justice gap, folks who just can't afford attorneys. Hardly ever do we talk about that as a market for folks who are able, as you say, to do it right, you know, whatever that looks like. It's super interesting. Now, so let's talk about that. What does it mean to do it right? Are you, is it just a sliding scale model and you're providing full services, or are you using technology, unbundling your services? How do you deliver?
Yes.
Okay.
We, you know, in order to do it, you know, I mean, I feel slightly insulted when I have to think about people who say, oh yeah, doing that is like kind of like doing the Walmart of legal services. I mean, right. Honestly, my clients don't have a lot of money, so I can't give them, like, I can't advise them, okay, let's have a $15,000 custody evaluation or a $10,000 custody evaluation. My clients can't afford that. So we have to find alternative methods of them being able to get their needs met and do what we need to do in their cases. And when you are representing people at lower rates, you do have to have more volume than you would if you're representing them at a higher rate. But that doesn't mean that you have to sacrifice quality, because with technology, you can be more efficient. You can create systems that will make sure you are providing people with really good representation. We do really well. We get good results for our clients because we work hard and we create methods that allow us to not get bogged down in the little things. And when you're working with a client that's lower income and you're doing sliding scale fees, you have a limited bucket of money to take from for them, and you have to pick and choose what's going to be the most important thing for you to spend your attorney time on to help them the most, to get the best outcome for them. You know, I was just, as I was working on this article, because the thing I'm working on right now is advocating for the continuation of remote hearings. I'm getting somewhat dismayed by seeing that, you know, when the pandemic started, everything kind of shut down, and then the courts were like, okay, well, nobody can come to the courthouse, so let's start using Zoom hearings and let's start being remote. And that was starting to get people back in the courtroom. And now, as the restrictions are being eased, I'm seeing a lot of judges going straight back to in-person, saying, oh, this is an in-person hearing. And for little things like a review hearing or an initial case management conference, or even a motion hearing where everything has already been submitted on paper, there's no witnesses are going to testify, but the judges are like, where this is going to be in person. And, or, you know, the same as some of those counties where they do, you know, your cattle call trials. Everybody shows up on Monday morning, and we're going to see who needs a trial. and you're going to sit around and wait to see what's going to happen that day as everybody goes through all these other hearings, and they're saying that's all going to be in person. I think that's the worst thing that could possibly happen to our court systems, because that is going to go from finally doing something that actually allows people to have access to justice, and then regressing back to the 18th century. I mean, it's insane. And I oftentimes get calls from people in counties that have very few attorneys. So they've already gone through every attorney in the county. So there's a conflict, and they're like, well, there's no attorney here that can represent me. Can you help me? And I need sliding fees because I can't afford it anyway. And I'm like, well, we can't go there because I can't commit to a case where I might have to send an attorney on a 4-hour drive for a half-hour hearing. It's not worth it for you financially to pay for that. And if the court schedules it for 9 a.m., I'm not going to tell my attorneys that you have to get up at 3 and drive to the middle of nowhere for a case.
Yeah.
But with remote hearings, suddenly everything's accessible. We could help people anywhere in the state and offer them this. In addition to that, it eliminates the drive time. So it saves my clients so much money. It allows us, we can represent people or go to hearings in multiple counties in one day without, previously it was, okay, if you're going to have 2 different counties, you can maybe do one in the morning and maybe do one in the afternoon, and that's it. Right. So I'm concerned that our judicial system is just waiting for the pandemic to be over to go right back to where it was before, because I just think it's the worst thing that it could be. And it doesn't serve people. It seems like it serves the judges who don't want to deal with technology, but it doesn't serve the people who actually have to use the court system to get the things that they need.
So it sounds like in that regard, it's not just trying to create those options and maybe make some allowances for these virtual hearings that's going to help you. We really need to get some rule changes that specifically authorize for specific hearings or to what extent, whatever extent, those remote hearings. And I think from what I'm hearing from you, unless that's specifically authorized and available to you before that agreement is signed, you can't take those cases that are, say, up in Bemidji or over in Grand Forks or things like that.
Correct.
But if you could have that in the rules that says, no, my client has a right to this Zoom hearing or remote hearing as opposed to an in-person, we have the right to opt over. We're going to exercise that right, that you would be able to expand even more and be able to offer your services to people a little bit more broadly. I suspect there's always going to run into a situation where, nope, this one ends up being in person because it's maybe the big one or something like that.
Yeah, there might be some situations where in person is absolutely necessary, but for the most part, I have yet to see a hearing that couldn't have been done remotely, and that wouldn't have been more as efficient if being done remotely. It needs to come from the top. It seems right now that the only mandate we have in the courts is that you have to wear masks, but everything else is a free-for-all, and the judges can do whatever they want. So some judges are automatically saying this is going to be remote, and we're like, okay, great. And some judges I get in bold, this is going to be in person, and then I have to submit something asking them to move it to being remote. I think it should be mandatory that initial case management conferences are done remotely. Those are 15 to 20 minute hearings where it's meeting the judge and asking if you want to do alternative dispute resolution. I have clients who are hourly wage workers. They don't get time off. They don't get personal time off, or if they do, it's very limited. And for them to have to leave work, go to court, park somewhere, spend the day waiting for their initial case management conference, then do 20 and sit around talking to me for an hour and paying for that time, and then spending 20 minutes with the judge explaining stuff to them that could have been explained to them easily in a video conference, and then having to go drive home. how is that efficient? That uses up such a huge chunk of their retainer just for that, or a review hearing where all we're doing is listening to, you know, feedback from a guardian ad litem or something like that. And that can use up 2 to 3 hours of time if you have to sit around and wait and the judges and the courtroom isn't running on time. And that 3 hours of time that they just paid me for that didn't result in any outcome for them or any movement forward on their case, that could have been used to pay me to go with them to a mediation. That could have been 3 hours that we could have used to start drafting a motion that really needs to be filed. Or they could have used those funds for, you know, filing fees or all sorts of stuff that would be better use of that money. And when you're sitting there working with somebody who's low income or middle income and you're doing sliding fees with them, again, their pot of money is limited. I can't go, okay, we just used 3 hours of it. Now you got to come up with a whole bunch more money every month to keep paying me. They can't afford that. They can afford smaller payments during the month, each month, but they can't afford these huge chunks that they're being told that they have to pay every month because we're doing something that is not always moving their case forward. And then, of course, unfortunately, it results in people thinking, you know, do I need a lawyer for this? And because they didn't need a lawyer for that earlier case that really they maybe didn't need a lawyer for, now they can't afford the attorney when it gets to the part where they really need the attorney, where it's going to be an evidentiary hearing and now they're out of money, where it's going to be a motion hearing and they're like, oh, I guess I have no money left because we spent it on the initial case management conference waiting around in court. It's just inefficient. And to be able to run a sliding fee firm, you have to be efficient. And it's unfortunate that we're working every single day towards efficiency, and it doesn't necessarily mean, and I don't feel like the judicial system is always doing that.
And one thing that we had a question, Susan agreed with the idea that we should be putting this into the rules and making this set firm that there's options for Zoom hearings at different points and different times. And then the question, what shall we do to push the courts? I will admit I did not ask the question initially to put this plug in, but I do want to throw the plug. The Minnesota Supreme Court currently has vacancies for judicial officers and attorneys for the General Rules of Practice Committee. I think there's also openings for the Special Rules of Practice. Getting into these committees is a good chance to say, we need to make some changes on these rules. If you're not able to get into these committees, reach out to the people that are on the committees, because those are attorneys and public service members that represent all of us and can make and advocate for those changes. So there are ways to do that, and I would encourage people that are interested in this to apply and to push for these changes, because like Emily, I agree there are a lot of situations for my clients on the criminal side where, as opposed to traveling down to Freeborn County for what is literally a 30-second first appearance, we could save that client some time and money and just have it set into the rules that my client is allowed to do a virtual appearance, and we're going to save everybody some. So
right. Your client probably could do it. Your client, who probably is told you have to be working, could do it from their job and not lose their job so that they can go to court.
Yes. And I will say, we had some hearings recently where wasn't any of my clients, but we did see clients that were there, and unfortunately they didn't turn off their video feed in time, and then they jumped out of the truck, grabbed their toolbox, started heading to the work site. And it did show that it allows people to continue on with their life. Hopefully people are taking the court system just as seriously, and they understand that there's significant ramifications, but it doesn't need to be something where they have to take a half day simply to show up for 30 seconds on the record in front of the judge.
Absolutely. I was actually listening to Law Technology Now, and today's episode had Judge Mary McCormick, the chief judge in Michigan, talking about their use of Zoom. Apparently, Michigan had already been planning to have Zoom as an option a year before the pandemic. And so moving into the pandemic, they just like started really implementing it, and they've had really good results, and they're making comprehensive changes to their court systems across the board so that when the pandemic is over, they're going to have these changes made more permanent and people able to use it, to the point where they're saying, yeah, you know, people say one of the big problems is access. Some people don't have internet access. Some people don't have smartphones. And they're like looking at, okay, well, YMCAs, we can put them in YMCAs, we can put them in libraries. She even mentioned people talking about food trucks, that food trucks are places that people see all the time. They're all over the place. And if they had a connection point there, that could make it so that people can actually access the courts much easier through these remote video methods. And I think it would just be wonderful if our court systems could stop arguing about should we wear masks or not, and instead start discussing how can we, at the end of this pandemic, when it's over, what changes are we going to be able to keep, and how can we start making sure that they are going to be workable when this is over? I feel like we're not doing anything comprehensive about how can we make it so that remote video hearings are going to be useful, are going to be fair. We're going to have standardized rules across the board on how they're going to work for people, so everybody knows what to expect no matter what county you go to. I mean, that would be, I think, more productive use of our time right now than many of the other things that I see happening.
We did have a question in chat here. Colleen asked, and I think, Emily, you came over from the nonprofit sector starting this out, so probably have a good response to this. I've read about sliding fee firms in other states that are structured as nonprofits. Did you consider becoming a nonprofit versus an LLC? If you did, why did you decide on an LLC structure?
I did not. Well, I briefly, with my law partner at the time, talked about nonprofit, but the reason why we didn't become a nonprofit is because in Minnesota, I mean, I worked enough with the legal aid organizations to know that in Minnesota, there's a small pool of money that all of the legal aid organizations are going after. There's the LSC money, and then some foundation money, IOLTA money, all that kind of stuff that is funding all these legal aid organizations. And it's a dogfight to get in there. So to become a nonprofit and be competing against them, one, would be super difficult. And I think unfair, because I realized when we put together our structure, we don't need to be a nonprofit. A nonprofit would mean that we need to have outside funding in order to survive. And we don't need I don't need outside funding. We can make a profit doing what we're doing. In addition to that, to be a nonprofit, you need to get a 501c3 status and have an executive board. And what you do then is governed by your board. It doesn't give you the abilities that you have as a private firm to be nimble and to make changes and to do what you want. And I wanted to have the freedom to do what I wanted to do with the firm and to take it the direction that I wanted to take it, to add attorneys when I want to add them, to add practice areas if I want to add them, to expand my office or move my office, and spend the money in the ways that I wanted to spend. So a nonprofit was not even an option for me, because I just, and the other thing is everybody thinks that the only way to do sliding fees is to be a nonprofit. And I've seen plenty of sliding fee nonprofits go out of business because they couldn't sustain the model. They couldn't get the funding, they couldn't run it. And I've seen plenty of, I've seen sliding fee firms that are privately held also go out of business because, you know, they had difficulties running it and keeping it going. And I think part of me has this like inner desire to prove that you can have a viable, very profitable sliding fee law firm if you do it the right way. And I think I'm doing it pretty well. It's working.
You're still here. That's that's the goal. I do see a few hands popping up for the participants, just so that everybody knows. Feel free to put your questions into the Zoom chat or in Q&A. and we'll pop those up as soon as we see them. One thing that I really appreciate you bringing this up with the nonprofits, and one of the reasons it sounds like that you decided to go with a for-profit but sliding scale business is the limited amount of funds out there. I serve on the Hennepin County Bar Foundation and Minnesota State Bar Foundation, and we work with a lot of other foundations around the state. And we see that those same groups coming in, they come in every year and they apply for grants every year. Why? Because they need to be funded every year. They need to get that money every year to be able to stay alive, to stay functioning, continue to do the good work that they do. And honestly, that, to me, the fact that we have to have these foundations to pay those grants makes me a little bit sad, because that means that we haven't found a way to make those organizations that do such good work self-sustaining in some way. They always have to keep coming back in order to survive for another year or two. Whereas
that's stressful too. That's another reason I wouldn't want to be I don't want to spend every year trying to figure out how I'm going to have enough funding to survive another year. That's super stressful. And that was something that every year when I worked at Legal Aid for about 4 years, funding was always an issue. Are we going to be able to maintain? Are we going to get the LSC grant at the level that we got last year? Or is the new administration or the change in administration going to result in a cut to LSC funding? Is our interest rates going to be high enough so that the IOLTA interest rate funds will be able to sustain what it gave last year? Or like now during the pandemic, I understand that interest rates have been slashed and IOLTA funds are super low, which means all these organizations that are now more desperately in need of funding because they're, bursting at the seams with people needing help, and with, eviction moratoriums about to be lifted and all that kind of stuff, the funding has gone down, and there's going to be struggles. I mean, I donate to legal aid organizations from my business because I can, and I don't need that kind of stress. I mean,
yeah, it's not one of those situations when, hey, we have a new nonprofit out there that's doing fantastic work, and let's fund them as well. Give us some more money that we can give out. There's not more money each year for new nonprofits and things like that. So that's why I think businesses like yours, with the sliding scale aspect, are so important.
Thank you. We work hard. But it's very rewarding. I mean, that's the other part of it, that, you go into law because you think you want to help. Most people, I believe, want to help people. And of course, you're in law school and you're idealistic. And a lot of people are like, I want that job at Legal Aid, and I want to help people. I feel like the model that I've created actually is a social entrepreneurship type of model. I'm helping people that need it, and I'm doing good by doing this. And one thing I always remind myself, no matter how much my heartstrings might be pulled about, a certain case or a certain person, is I realize that if I don't run it like a business, it'll run into the ground, and then I won't be able to help anybody. So I have to always remember that there's so many people that need this, that I can't get myself bogged down in a situation where I'm not collecting fees, or everybody on that's a client isn't paying me, and they're now all become pro bono cases. You can't get into that. You can't let that happen so that your firm can't function. I mean, you have to be able to function to be able to help people, and you have to be able to be financially viable to be able to help people. So that's something that I work on, all the time, making sure that we're going to be in existence the next day and the next day and the next day and the next day.
Seems like you'd be a great resource for CCLI. Are you familiar with?
Yeah, I work with Karen all the time.
Yeah, great. She might be on Yeah.
Yeah. I've done a few presentations for CCLI, and I think that's great. They're helping people to set up their practice. I think the one thing that I had when I started my practice that I think allowed me to be more successful is I actually had experience under my belt working in the area of family law. So I didn't have to open the doors and figure out how to run a business and figure out how to practice family law at the same time. I'm not sure if we would have been as successful in that. I believe that people need to develop that skill. So that's kind of more second nature, and also have a real desire to understand how a business runs in order to make this successful.
And Emily, we had a question from Susan pretty early on, but I think you answered it, but I just want to bring it back up. Yeah. I hadn't asked it at the time because I thought you were answering the question, so I'll bring it up again. How much have you had to sacrifice response to clients due to sheer volume of your cases, or how do you handle responding to requests from attorneys and clients?
Well, we have a lot of different attorneys working. I mean, I have other attorneys. It's not just me. And we actually have more of a team approach. So a case doesn't usually has a primary attorney, but that doesn't necessarily mean that's the only person that's going to work on it. And so we've been able to if one person is super busy, we have team meetings where we talk about the cases and what's going on and exchange ideas. So, we all can kind of jump in if we need to on a case and help each other and be responsive to a client so that the client's not feeling left out. And part of it also, and the pandemic has allowed me to kind of be at home more and be, I'm not driving to court all the time and all that kind of stuff. So I've been able to spend more time working on more of my systems and processes. And so we're doing other transformations to help make our firm more effective and responsive, and have and use the technology that we already have to give our clients better, even more exceptional service. So that's kind of where we're at.
And I'm kind of curious on this. So when we look at the criminal side, if you look at the number of cases per attorney and you compare it, public defenders, well, you will have some public defenders that will say that they have 140 cases at any given point in time. Maybe I'm not going to tell them that they're not telling, but I do have other public defenders who I know are carrying caseloads of 60, 70, sometimes 80 cases at any given point in time. Private attorneys all across the board. Personally, I try to keep my case number count well under 20, just so I can give the quality service that I like. Where are you at? And if you don't want to talk about it, but for number of clients per attorney, I don't know how that would reflect in the family law side of things, but if you could compare it at your office versus, the nonprofit that you work with.
So at Legal Aid, they kind of let you pick and choose the amount of work you wanted to do. And that was so long ago, I don't really remember. I don't feel like I have much of a different level of caseload, because you could limit how much, at Legal Aid, you could limit how many people you're representing. And I think right now, I guess if we average the number of cases out, open cases that we have, I don't know, we're somewhere in, the 20s for number of cases. The thing is, it depends on the nature of the cases. Like some cases are really fast. It's like, we're just going to file it. We're doing a motion and we're doing a motion hearing and now we're done. And, you're finished in 2 months or a month or whatever. And some cases are these long drawn out divorces. So the nature of family law cases are different. I think in criminal law, it's probably the same thing. You have, in the nature of criminal law, from my understanding, which I've never practiced in criminal law, but it seems like, my former law partner, Tracy, now works as a public defender in juvenile court. So she does a lot of criminal law stuff, but there's investigations and tons of evidence and videos that you need to watch. to really prep a criminal case, the way it should be to give the, Johnny Cochran kind of defense, it takes hours and hours and hours, and family law cases in general, most aren't going to take that kind of investigation, right? Especially ones with people who are lower middle income, because they don't have a lot of assets to investigate. They don't have, most of their issues are about the kids, and those are not as much about, watching all sorts of videos and everything, but helping people to craft a plan for their kids that works for everybody, or helping people who just have horrible communication skills and shouldn't be married or shouldn't be together find a way to cooperate for the sake of their children. So it's a different, I think, landscape when you're talking about family law.
Yeah, and you have the same thing on the criminal side. Like you said, you have cases that will sometimes have video evidence and testimony from multiple different sides. And then you have the case where the guy got pulled over on squad cam, driving without a valid license, knew he didn't have a valid license, and there's not a whole lot to investigate.
Right.
You just try to give the client the best representation and get them the best outcome they possibly can.
Right.
Yeah. So maybe the case per attorney is a little not accurate, but it's interesting to know kind of what seems like an excessive number, what's an average number of individual clients per attorneys. I'm curious. Speaking of the public defenders, I know we're over time already.
Are we? Oh, okay.
But I'm curious. I've heard some people talking about, given the massive numbers of unrepresented individuals, especially over in family law, I've heard people talking about we should have a public defender system for family. I know that this is way out of the ballpark, completely different topic, but I'm curious on your thoughts on that. Some type of public defender system or public representation system of attorneys for people that qualify over on the family side.
I don't know. I haven't really thought about that a lot. I know, I mean, I just don't even know how feasible that would be funding wise. They can barely give enough money to public defenders in the criminal side. And public defenders in the criminal side are like overwhelmed. I get calls from people who qualify for public defenders in juvenile court who don't want a public defender because they don't think their public defender can serve them well because they have so many cases and they're so busy. So, I mean, I think people do better in court, get better outcomes in court if they have good representation helping them. And I also think, and it's something that I struggle with a lot. So we have all these self-help kiosks and clinics and all these things for people who are low income to help them with family law type things. And it's kind of, I think it's really, interesting that if you have a lot of money and you're well off, one of the trappings of being well off is having great technology. You have the best computers, you have the smartphones, you have the best Apple Watches, you have this and you have that. And if you're poor, you have, a pay-as-you-go phone that you have to ramp up with more minutes after, it runs out after your first 500 or whatever. But in the court system, if you have lots and lots of money, you get the personal attention of an attorney who's there to represent you, to take the stress off of you, to walk you through the system, to argue for you, to speak for you, to write everything so you sound fantastic. But if you're poor, you get a computer kiosk where you have to try and find the answer to what you're looking for, or some kind of online technology that's going to try and push, but you don't get that personal attention. And that, I think, is the problem, because if you're poor, you may have, your educational level might be lower, your comprehension level might be lower. And those are the people that need the personal one-on-one from an attorney the most, and they can't get it because they don't have money. So, that I look at that as being one of the failings of our legal system, and that's why one of the reasons why I started the practice that I practice.
So, and this is my last question, I promise. For those people that are out there and they want to do something similar to what you're doing, they want to get out there, they want to help, they want to be self-sustaining, so they're not asking for grant monies, but actually help try to address the access to justice gap, whether in family law or in a different practice area. From all your stumbles and your steps and getting up and running and all your successes, besides reaching out to you, what's the number one resource you'd recommend people look into or work at?
Well,
last question, so I thought I'd make it a difficult.
Yeah, make it the most difficult one ever. There aren't really any resources. I think that it's incumbent upon attorneys to find a group that helps them on the business side. You are never going to be successful if you don't get some business training. You're not learning it. You didn't get it from law school. So you need to learn how to run a business if you want to have a successful business. I happen to be a member of Lawyerist, and I've also been a member of How to Manage a Small Law Firm. And those were two pretty good experiences that I had. Personally, what I would love it if people are doing sliding fees, and it's hard to find people doing it because not many people are as just blatant about it as I am and throw it out there. But people who are doing sliding fees, I would love to create a cohort of some kind where we can meet on a regular basis to discuss. I really want to grow this area and help people to be successful. It's been tough because I've met people at different events through the bar that I've done presentations at who've been like, I want to do this, I want to do this. And then you don't hear from them again. And it sounds like their businesses are super struggling and they've had a difficult time. So I think it's something that I'd really like to do to move this forward. Like, as I said, I mean, I can't handle 60,000 cases a year of family law cases a year. That's impossible. And there's plenty of people that need that. And if you do it right, it can be a good thing. It not only making you feel like you're doing good for the world and good for people and actually using your law license for advancing our society and making change and creating access to justice, but it also can allow you to feed your family and and clothe your family and pay your mortgage and pay your bills too. I mean, they're not mutually exclusive. Helping people and actually being able to live a good with a good income are not mutually exclusive.
Thank you, Emily. I need to call time. I'm so sorry. It's just a great conversation. Thank you so much for joining us. Before we part, though, you have an upcoming article in Bench and Bar. Is that correct?
Well, I'm working with Steve. I had like 5 different topics 5 or 6 that I'm like, these are the things that are eating away at me that I want to do something about. And so we're trying to figure out if I'm going to write like something about each one or if I'm going to just write one. I worked on one yesterday. And so he told me just go start writing. So it's talking about things like remote access. It's talking about LLLTs. It's talking about access to justice. It's talking, a few other things that just stick in my craw that that hopefully we're going to do some articles on to put that out there. And it's my opinion on different things, and so people don't need to agree with me, but I think these are issues that should be addressed because in addition to representing and doing sliding scale fees, I'm a huge advocate for people who are lower and middle class. And I see so many things in the court system that just are oblivious to how it affects that group of people. And as an attorney, I feel like, isn't it my duty? Isn't it our duty as attorneys who actually work within the court system to speak up and say something about that and try and
Or as
make
an
change.
association, sure, yeah.
Right. To try and make change for the people who actually the court system was designed for. They're supposed to be the ones that dictate how the court system works. It's their court, not ours. And it troubles me that there's so many things that are created for the convenience of the attorneys and the judges that are so inconvenient for the people who actually have to participate in the court system.
I'm really looking, that's the September issue of Bench and Bar, I'm assuming?
I think so.
Okay. I think August is out, but all right. We'll look forward to that. I'd say, be provocative. Don't hold back. I'm really excited to read it.
I'm having Tracy as my editor, and she has to always hold me back. But so we'll see what comes out.
I don't know. I don't think Steve will.
She has to take certain things. She's like, okay, nope, you can't say that. Can't say that. But
is there going to be an unedited version somewhere? I think I'm more curious in the unedited version now.
Depending on the day, there probably will be some unedited versions out there.
Probably should start out as a blog post first, then we can
We'll see what comes out on the site.
All right, thank you so much. You all have a great rest of your week, and stay safe, everyone. Thanks.